Yes, ladies and gentlemen of the press, what I said and what my two colleagues have said can be summarized as follows. One, recall that Nnamdi Kanu's case was commenced almost over 9 years ago when he was first arrested in Lagos. Recall also that he was then charged with offenses relating to his broadcast on Radio Biafra from his location in London. You can imagine what it means for someone to be on an endless trial that never really happens for almost 10 years and being detained without conviction for 18 months, initially from 2015 to 2017, and again for over 3.5 years from 2021 to the present day. This alone is a gross injustice of its unique kind. Two, it's also to be recalled that after Nnamdi Kanu was freed on bail, Nigeria's army levied these lethal attacks against him that drove him into exile, involuntary exile, from which he was also renditioned in 2021. And recall the decision made in 2018 by the African Union that everything that has happened to the IPOB from 2017 to that very date, and of course, much worse happened after. Recall that those things were declared illegal and unlawful and as having violated the African Charter at a continental scale. Now, also, the same action, in particular, the proscription of IPOB in 2017, provoked or triggered the rush of litigation that eventually culminated in the ruling of the High Court of Enugu State, declaring that such actions by the federal government of Nigeria against Nnamdi Kanu and IPOB are unconstitutional. So the question to ask is this: why is it that the IPOB, being of Igbo stock, it is not us as legal team making allegations? We have rulings of the international community. In the same vein, we have rulings of municipal courts in Nigeria indicating that what is happening to IPOB is nothing more than an ethnic-driven persecution. Three, now having survived the lethal attacks and having survived this many years in enforced exile, and having undergone all these tribulations and travails, and having been renditioned, these actions, this very action of the federal government of renditioning Nnamdi Kanu triggered the international legal order. In July 2022, the United Nations Human Rights Council came down with a gavel that Nnamdi Kanu was extraordinarily renditioned, and that it was a violation of all canons of international law to which Nigeria is subject, and it recommended a generous compensation to be paid to him and cessation of his prosecution. That was ignored by the federal government. Four, it is noteworthy that on 29th June 2021, as indicated before, Nnamdi Kanu was arraigned, well, you can say produced in court, albeit secretly, through the back door, and presented before Honorable Justice Binta and Nyako, who was aware that Nnamdi Kanu had counsel of record. The prosecution was aware Nnamdi Kanu had counsel of record, not us, his former lawyers. And the DSS was aware of the information of his counsel of record. Everything was on file. Yet, Nnamdi Kanu, or the court, conducted hearing over the head of Nnamdi Kanu and remanded him to DSS custody without notice to his counsel not to talk of presence of his counsel. This is a flagrant violation of Section 36 of the Nigerian Constitution. 5, when you fast forward to October 2022, when the Court of Appeal discharged Nnamdi Kanu, there was also a judgment issuing from the Federal High Court sitting in Umuahia, which had declared his rendition from Kenya as unconstitutional. It didn't stop there. It went as far as declaring his continued detention in Abuja as unconstitutional. What will you do or expect a responsible government to do when the detention of her citizen is declared unconstitutional? You open the gates of the detention center and allow the citizen the free pass to go home. That's what Nnamdi Kanu deserved to have been done with him since October 2022 when that judgment came, but the federal government never did. That's part of the reason why we are saying his detention has turned extrajudicial and is no longer backed by any court order. 6, regarding the December 2023 judgment of the Supreme Court, which people are touting as having sent Nnamdi Kanu's case back to the High Court for trial, it doesn't end there. If it ends there, then it's a mischievous conclusion. The court went further. He said Nnamdi Kanu needs to go back to the High Court for trial, but it also said the High Court should not have revoked his bail. It also said that by revoking his bail, the impartiality of the High Court judge had become suspect. Ladies and gentlemen, you may not be lawyers, but when the apex court of the land tells a High Court, you should not have done this, what remains is for a High Court to do that which, or undo that wrong which he had done. And Section 287 of Nigerian Constitution backs this up, because under that section, all subordinate courts in the country, or all courts in the country, are subordinate to the decisions of the Supreme Court. It never happened. 7, now talking about the much vaunted trial of Nnamdi Kanu, we raised objections to this trial too, based on the conditions of his detention, which were very stringent and highly prejudicial to his right to fair trial. This application was summarily denied and an accelerated trial was ordered in its place. We raised a second objection based on certain constitutional infirmities and statutory issues we noticed in the charges facing against Nnamdi Kanu. This too was summarily denied. So if you were Nnamdi Kanu, what will you do under the circumstances? To succumb to a trial you knew in your heart to be going towards the trajectory of an unfair trial, or to seek alternatives to that. 8, having considered those factors which we enunciated, Nnamdi Kanu felt that the only fair way out of this logjam is to seek that his case be handled by another judge. Hence, the recusal, the famous recusal that is still roiling the system. And in concluding this press statement, ladies and gentlemen of the media, we must go on record to say this. As lawyers, our duty is to ensure that Nnamdi Kanu's case is conducted or handled in accordance with all the laws pertinent to it, particularly the Constitution of the Federal Government of the Federal Republic of Nigeria, which is the ground norm. In our view, this has not been the case, and the evidence is legion, as all who have dispassionately followed the trajectories of this case would agree. On this score, ladies and gentlemen, we make bold to state that this case has turned from the legal and the judicial to the political. This is perhaps the reason why there is a broad spectrum of persons and organizations calling for a resolution of this case outside of the judicial part, also known as political solution by baptism. These calls range from the international to the domestic, including members of the Senate, House of Representatives, the clergy, CSOs, eminent lawyers, and many others too numerous to mention. Be that as it may, and judging from 2015 when this case began 9 years ago, there is a trove of evidence that suggests that the only way to correctly describe what Nnamdi Kanu has passed through for almost a decade is to say that his case, even though bereft of merit from the very get-go, has turned from a trial to be conducted under the Constitution to a trial by ordeal. This is perverse and it will not stand. Thank you. Yes. If you, okay, get whoever wants a soft copy right here.